Amaryllis Müller, Miranda, Stijn Huijts. Welcome to Digital Markets Research Hub. Earlier this year, the TL4 Competition has organized yet another very thoughtful event called the EU Digital Markets Competition Litigation and Compliance Forum. And Miranda and Stijn were co-leaders of this really informative event. Amaryllis were chairing very interesting panel. So I decided to invite you for a kind of conference debrief, and perhaps with the first round of conversation, maybe it would just make sense for us to reflect upon the situation within the EU and UK, perhaps digital markets regime. Are we moving with the right speed in the right direction? Do you see some clusters of main stakeholders which can be somehow developed into schools eventually? And are you satisfied with the speed and direction? Maybe let us start with you, Amaryllis.
That's a very large question with a lot to unpack. I think we're in this interesting position where we're about at the 2-year mark now of the DMA being into force, which is on the one hand a very short time, but a lot has happened already. In this time, we've seen already 2 non-compliant investigations going into fines. We've seen specification decisions. We've seen market investigations and many others. And at the same time, we've seen a lot of compliance discussions ongoing very intensely with the gatekeepers. But at the same time, 2 years is not a very long period of time to really distinguish enforcement patterns and see, how the Commission might be moving from the initial phase now into a more established way of working. But I think in assessing the DMA, obviously, it's always the question what you hold as the right benchmark for effectiveness and effective digital regulation. And there, also echoing what has been said at the conference, is that a lot has changed already. You see how ecosystems have been opened, there has been more interoperability, there has been more user choice, data portability, but then obviously there is also a lot that might still need to happen and for which we will look at the future developments.
Thank you very much, Miranda.
Yeah, I mean, I think as Amaryllis said, it's sort of, 2 years is both a long time and not long enough. If we think about, there's a couple of things I would kind of, when I think about where are we not with the DMA. As Amaryllis said, there's a range of different types of cases that the Commission has started. If you talk to Directorate J, you get a very strong kind of feeling at the moment that they are particularly interested in running specification cases. And I think part of that might be coming out of, some of the difficulties that they're running into with some of the non-compliance cases that haven't yet led to a decision, and or fine. So, the one that has been in the press recently, for example, is, the Google search, the 6.5 case, which is now slightly over 2 years old, 2.25 years old, which, was not what the Commission was aiming for with the DMA or any of the institutions, to be fair. Given the discussion at the time leading up to adoption and the negotiations over the text about timing, immediacy and all the rest of it. And I think if you talk with people inside the Commission, that you can see where the appeal for specification decisions comes from for them, right? Because the timeframes are shorter, and as is inherent in the nature of the beast, they get to specify what it is that the entities do. Because even with some of the cases where they've taken decisions so far, the discussion, the final resolution of what is a measure going to look like that is compliant is still ongoing. It's still open. There's still discussions with the market, etc. So I think one of the things we have seen is, whilst the DMA does without doubt speed up a normal 102 or competition investigation, I'm parking interim measures for 1 second here. It's still not I'm just going to say it's not a magic bullet, because they still have to go through this exercise of, even once they found, for example, non-compliance, what does compliance look like? And so there is that element that was part of, the frustration, I think, in some quarters over the use of Article 102 is actually still there when you just look at the non-compliance structure rather than taking into account specification. Sorry, I'll let go on.
No. I just wanted to double check. We have specification decisions last year, two specification decisions. What's your flavor? Do you think the commission and the stakeholders that are happy? Is it moving in the right direction, or it's too early to judge? Do you think that we are already using this mechanism deliberately, knowing that it can work?
I mean, I think the commission is quite deliberately used. So as you say, there were decisions last year, but there's also two open cases, right, at the moment. So you've got the proceedings about basically what forms of access that Gemini has to Android features and whether they are available to others. So that's an Article 6.7. It's substantively it's Article 6.7. And then there's the second one, which is the FRAND terms for access to the anonymized search, ranking, query, click, I think, view data. So that's the 6.11 investigation. And they're quite different, clearly, on the substance. And I think they sort of illustrate the point, together with the earlier Apple cases, that where the commission thinks it is something where it can technically identify what it would like to see happen, it is likely to go down that road. Do the gatekeepers who have been and currently are subject to those specification investigations share the commission's view? Well, the Apple appeals suggest not. And I can't speak for Google, but my understanding from what's in the public domain is, there is some concern on the Google side about what it is that the commission wants to see. So I'm not suggesting that the gatekeepers and the commission are aligned that this is the way to come to a common view of what's required. It just appears to me, at least, that the commission is taking a view that this as an avenue gives them more input into the measures that a gatekeeper takes. Whereas under the non-compliance cases, if you look at the market investigations that were begun after the 60-day period that the non-complying gatekeepers are being given, those are yet to reach resolution on what is the appropriate measure. And I think that is creating a fair degree of frustration inside the House, both the commission side and also sort of the more political layer.
Maybe if I can just pick up on that point, because on my panel, actually, Lucia Bonova spoke as well. And then actually I asked her the question, how does the commission pick between non-compliance, specification, or even just continue the regulatory dialogue? And the message is clear that to the extent something can be solved through the regulatory dialogue, that's still the preference.
Sure.
And then between non-compliance and specification, she said that it really depends also on the kind of the case, and that it is really for highly technical cases that really lend themselves to these kinds of specification proceedings, that is then an avenue that they might consider, other than obviously when there is clear non-compliance. I think there is positives and negatives to a specification process. On the one hand, indeed, whether you like the outcome or not, there is some more clarity, which, as Miranda, you rightly pointed out, there wasn't in the non-compliance decisions, because the commission actually refrained from telling what the measures would be. On the other hand, it is also a very short time frame. It's only 6 months in which the commission has to deal with super complex issues. I think they have really the best intentions to do that as thoroughly as they can, coming to these meetings with, really technical experts on the side of the commission as well, meeting the technical experts at the gatekeepers. But it still means that some of these technical issues might be dealt with in a time frame that's maybe not realistic to get to the bottom of things, in the best way possible. And I ask myself whether there is also a way in which you could do non-compliance decisions in which you also specify or, talk about some kind of commitments process, which we know in antitrust proceedings, and not leave it fully open-ended, but have a longer time frame than necessarily the specification decisions for the Commission to give a bit more steer on the compliance measures.
I mean, I guess as a matter of law, that is possible. It's just not the way those processes are working, right? And so, you're absolutely right about, the Apple cases and even the Android access point, right? Very technical cases. I would suggest maybe that the FRAND terms for access to the search data, though, is a little bit less in that technical camp and a little bit more, as in it's not all about how do you interoperate, what is the access point. It's not purely technical.
That is true, but if
I think
may...
we're seeing, I think we're seeing, from discussions I've had with various people inside the House, there is a view that if they're running into effectively an inability to have that regulatory dialogue you're talking about, that the specification process is something that, has certainly not been characterized to me as being pigeonholed only for technical type areas. That it is viewed slightly differently to that, at least from others. Now, Lucia, I mean, one can only assume that different people inside Directorate J have slightly different views about this.
Maybe also one thing we can lose sight of is that it's only applicable to Article 6 cases and not Article 5, which are meant to be self-executing. So that's the thing. I would still, just very briefly responding on the 611 case, the data sharing one, disclosing that I have been involved in that one. We do see some very technical discussions of how data needs to be anonymized before it is transmitted to third parties, which is a highly, highly technical matter, also including privacy experts, and actually one that is very difficult to solve within a short time frame. So I would maybe, make a note on that one.
Yeah, no. My point was in that context, that makes everything under the DMA technical, right? I mean, realistically, everything we're dealing with here is in some way, shape, or form technical.
I propose let us pause here because I think it's a very interesting avenue of conversation and invite Stijn to maybe masterfully reflect upon the development on the DMA and yet manage to somehow look at connect it to the issues which have been already addressed.
I'm not sure it's going to be masterful or less, but I'll try. I think that maybe in the run-up to the adoption of the DMA and also the DSA, which were of course adopted as a package, there was maybe a hope among policymakers that some of these issues would resolve themselves almost, that the addressees of these regulations would fall into line, that the very fact of having the regulation would lead to changes in these markets. I don't think that has really happened. I don't think, for example, that you can compare this to the situation with the GDPR, which of course has its own issues, but where I do think a big compliance exercise kind of happened across the economy really after the adoption of that regulation. Whereas here, I think there's a real issue around the Commission having to, you might say, work with, or you might say work against, some opposition from gatekeepers, and that should perhaps also be seen in the political climate where these regulations were prepared and adopted under a political climate that was maybe more favorable to regulation of digital markets, and are now having to be enforced in a climate that is maybe less favorable to that. But that is what it is. I think there is clearly some really hard and technical work being done by the Commission and by the teams also advising gatekeepers, and people are having to get across extremely technical issues there. And at the same time, we shouldn't forget that antitrust cases are also playing out in the background, which are having a major impact as well. So you have the Meta WhatsApp case, of course, which is not only a European case, but also a Brazilian and Turkish case. You have Google AdTech, which is, of course, also both European and US. And more generally, you have the private enforcement cases, where in the Kent case in the UK, actually a court has found that Apple's commission is unlawful, a charge at 30%. And so, we shouldn't forget about those developments. If we focus too much only on the DMA and those highly technical discussions that are happening in Brussels, in the Madou Tower, we kind of risk losing the woods for the trees. So ultimately, I mean, is the DMA effective? That it's way too early to ask that question. I think it has not really led to a sort of situation of self-compliance or self-regulation in the way that some other regulations might have done. But at the same time, I think it is achieving an opening of ecosystems, as Amaryllis mentioned. And I think I'm also encouraged by the fact that some gatekeepers are also looking for opportunities to use the DMA to their advantage in areas where they are not occupying an entrenched position. So that must mean that there is hope there as well. So overall, I think it's too early right now. I think the Commission has to continually look at whether what they're investing time in is really the right thing to invest time in. And I think there's a real need for DG Comp to continue to look at the bigger picture and ensure that whilst all these technical discussions need to happen, of course, they don't lose sight of that bigger picture, and they continue to try and deliver on the ultimate objectives of the DMA, just to introduce fairness and contestability in these markets.
But this leads us back, thank you very much, to the question of technical, because it looks that the obligations, the catalog of obligations, as well as some other procedural aspects of the DMA, at first glance may appear to be, or at least Article 5, self-executing. There was such kind of phrase commonly used in the past. And now, once we start looking deeper and once the stakes increase, any compliance element can be problematized and getting more technical, and there are procedural elements which are mandatory. You cannot just say it's just you try to overcomplicate things, because they are embedded in the texture of law. So you play in this game again, all three of you, acting in different capacities in favor or against specific provisions of the DMA, I imagine. I wanted to maybe to ask you to elaborate upon this texture of law. Is it will it be ultimately for the General Court and the Court of Justice to be the arbiter, or where should it be stopped? How much discretion will the Commission be given? Can you do a little bit of kind of crystal ball gazing, leading us, navigating us across 26, 27? What will happen with the DMA in the following 2 years? Amaryllis, maybe let's start with you again, with another kind of general question.
Yeah, general question. No, maybe just picking up on this kind of self-execution point just before going into the crystal ball gazing, just also briefly taking stock on that. I think that was very much the idea, right, of the DMA, that, okay, we're going to basically take all these 102 cases, to some extent 101 cases, and put them in a clear article so that we don't need to face this whole large case analysis that you usually have under 102, speed things up, make it very clear. Indeed, as you say, that hasn't always worked out for different reasons, because there's a lot of technicalities for each of the articles. Sometimes the issue is also that the DMA basically cuts across a lot of different business models and the way different companies handle their business. I know I've been at the very, inception of the deal or application of the DMA at gatekeepers, where they really just had to figure out, like, okay, what does this specific article now mean for my business model, and they had to devise and come up with a plan how that would work. And then in the regulatory dialogue with the Commission had to come up with ultimately a compliant solution. And then obviously to the extent there have been some disagreements with the Commission on how compliance would look like, and to the extent the gatekeeper felt that they were actually on the right end of the interpretation of the law, or just something that wouldn't work based on their business model, some have taken a position that maybe then ultimately the Commission didn't agree with, and that would then be contested in the courts. And ultimately, it would indeed be for the courts to weigh in on these proceedings, on these topics. I think, I like kind of how Lucia put it as well, is that basically the DMA has kind of passed its teething phase at the moment. Like we've had like initial issues that we're dealing with, but there is still a lot of learning and maturing to go through. And what she said is like, look, it is all very new, so no one really has the truth in, on their side. We're all just trying to make it work, applying it in practice, have dialogue about it, and to some extent disagree. And to the extent there are such disagreements, it's very healthy that there is a review by the courts. And she also really welcomed that and said, look, we're trying to get it right. But to the extent we don't, it's good to have that clarity in the future of the courts, and then, move on and apply it in a different way.
Thank you, Miranda.
Yeah, and I think one of the things that's very, to Amaryllis's point about, each of the gatekeepers trying to work through 2.5, 3 years ago in advance of being, actually subject to the obligations. What does it mean for my particular business? And then sort of as the rubber has hit the road and people are starting to realize, hold on a second, the Commission is also looking at the application of that same provision to that gatekeeper, and they do something that is different to us. And the Commission, of course, has to square the circle and make sure that they are applying consistently across entirely different services, right? Things that are fundamentally different. And that's one of the issues a little bit with the DMA, in that it's sort of, square pegs have been forced into a number of round holes, let's put it that way. And I think we're really seeing that now when, we've got this third AI investigation, the market investigation that's open, where basically the Commission is more or less said, look, we know a lot of these obligations simply aren't going to work in relation to certain AI issues. What should they look like? I mean, I'm grossly paraphrasing, but that's the gist of it, right? We have this whole series of obligations out there, Article 5, 6, of course, 7, but not so much, I don't think, for AI, where you've got a whole series of obligations that are very specific. And, in the case of various parts of Article 6, for example, apply to some CPSs, but not others. And you can see, particularly as CPSs were added at the last minute into the scope of the CP, the list in Article 2, that there may well have been something of a disconnect between the CPSs covered and which obligations apply to different CPSs. And so we now have a situation where, to come back to Stijn's point a couple of minutes ago, we have some competition cases and some DMA cases running in parallel on not dissimilar issues, because the particular CPS, for example, wasn't in scope of the relevant obligation under the DMA, just as one example. And so we do still have this parallel track of the DMA cases, the competition law cases, and frankly, as more things like dark patterns start to come to the fore, which I think they will do in the next, to your future gazing question, Olive, in the next 12 to 18 months, it's going to become much more important, because let's face it, as various AI features, functions, services are rolled out, there's already a debate raging about, whether or not there is distribution advantages are being exploited inappropriately or not, etc. And that is going to bring in a lot of those discussions around things like dark patterns, and that will pull in the DSA, the AI Act, and a bunch of other things as well. So the landscape, if you like, is going to get much more complicated, because we're probably looking at a situation where there will be a number of additional AI-related cases. I mean, we've already got quite a few. And that will be happening against a list of obligations that the Commission has effectively already said, well, more or less, we don't think this is final. This is something that needs some more work. They're I think fairly clearly hinting that they're looking for some sort of delegated act that they may modify the scope of the application of some of Article 6 in that context. So there's going to be I predict, a lot of movement on that side in the next 12 to 18 months, frankly, because there has to be, and the Commission has said that they're trying to ensure that they use the DMA, including the interim measures aspects of it, to try and avoid a situation where, there may be some degree of foreclosure because, they can't act fast enough, for example. So I think in the next, my guess, 12 to 18 months, that's an area where we're going to see a lot of future activity. And then one thought about the European courts, 100%. I mean, I think that the Directorate J people are very transparent about the fact that, they welcome the court's input. I think it's also not just going to be through the General Court. I think we're going to, and we're already seeing this now, the number of actions in member state courts where people are, seeking injunctive relief. So far, very few of those applications have succeeded, but they're there and the number is increasing. I think there's a decent chance that we're going to end up starting to get references to the Court of Justice on points of law coming out of those cases too. So we're going to see, I think, a fragmentation that, as Stijn said before, the Commission only has so many resources they have to prioritize. When you get business users who haven't been prioritized, I suspect we will see them in national courts trying to use that route to get, their question aired and addressed by the court.
Thank you very much, Stijn.
Yeah, and I think, alongside the DMA, I think that there are three key developments that will continue to play a big role and that people will continue to debate and perhaps try to use to their advantage, which are Google Shopping, which set that big precedent on self-preferencing, Android Auto, which set a huge precedent on the inapplicability of Bronner in certain contexts. And then I think also the Commission's approach to unfair trading terms in the Apple and Facebook marketplace cases, which are still under appeal, and we should see where that goes. But those three, I think, also set some really important precedents outside the DMA, which will continue to influence more generally, I think, the issue of competition enforcement in digital markets. And it's very interesting in that respect that these cases involving AI, so, we have the Meta WhatsApp case and the Google AI Overviews case. They're both actually antitrust cases rather than DMA cases, whereas I think at least for the Google one, definitely commentators were pointing to potential DMA options there, but the Commission clearly opted for going the traditional Article 102 route. But those are still, are those AI cases or are they cases about a gatekeeper or a dominant firm using their dominant position to promote their own new product, which in this case happens to be an AI-based product? And I think we still have to see where, AI obviously being a revolutionary new technology, where that's going to lead competition enforcement and DMA enforcement in the future, whether that will create new competition problems that are still, difficult to define at this stage.
And can I just chip in with a thought there? I agree 100%, Stijn. The other angle to those cases, right? Both the AI overviews and also the YouTube content case, right? There's the preferencing set of issues. There's also the use of data, allegedly without a real opportunity to consent and without compensation. And I think my understanding is part of the reason for going the 102 route was the compensation point. But it's an interesting one, though, because to come back to your point about shopping, that kind of use of content claim has been out there since literally the early days of the Google shopping case, where a number of the vertical search providers were essentially saying, well, what the claim was that what was happening with Google's own vertical searches, their own search products, was that they were effectively taking the live feeds that they were being given by other vertical search providers and using that to build their own product. So the argument was that, essentially the Google product was a wrapper being put around content and databases and things that others had spent years building and maintaining to offer the new service. Now, that claim was being made 12, 14 years ago. So there is that as a part of those two cases that Stijn just referenced, that I think is also one of the other reasons that they went under competition, because at least as a matter of Article 6.2 of the DMA, you can't get consent from a business user to use their data. It's an outright prohibition. So it's an interesting question about how that fits. But yeah, I 100% that those three cases are also, like the competition cases, are also feeding through into the thinking about DMA.
And I think it
And
might.
there, I think the use of content is going to be a big battleground. And of course, some of the AI, let's call them AI companies, are not gatekeepers, may not even have a dominant position, but probably still rely on content in some way, shape or form, through their large language models. And a question is this a competition problem or is it more a copyright issue? I think the Parliament is looking at updating copyright laws for that purpose, but I think that's definitely going to be an area of attention for 26, 27, where, of course, in the UK, the CMA is kind of dipping its toe in a little bit now with the conduct requirements for Google. I mean, not quite saying there needs to be fair compensation or anything like that, but they are now saying, publishers need to be able to opt out of AI overviews. Without that meaning, they wouldn't be listed in Google search or indexed. And that is, arguably a first step towards doing something for publishers as a potential group of stakeholders that could be harmed in the AI context. But it's something that the CMA can only really do with respect to a company that has SMS status, like Google in that case. But it's not a solution for other AI providers, Perplexity or Anthropic, because they do not have SMS status, at least at this stage. So I think this is going to be a very interesting area to follow. Yeah.
Yeah,
and it also ties in, just very quickly, Amaryllis, sorry. It also ties into that recent Meta judgment, right, on the DSM, the Italian implementation of the DSM directive. So to your point about copyright, all of these other kind of threads, the other regulations are also, front and center as well, I would say. There was an interesting ruling from the court a couple of weeks ago about the potential for a member state to require compensation. Sorry, Amaryllis.
Yeah, I just wanted to make the point that all of this context feeds back into what the Commission is doing with the DMA and how they see it going forward. Because I feel like, the initial enforcement was really based on the codification of these previous 1 or 2 cases, but now they're starting to look a bit more creatively at the DMA and what the provisions could do, which I find specifically reflected in the use of 612 and the use of France. Now with the Google site reputation abuse policy case, where I think, it's not necessarily how we thought would be kind of the tip of the iceberg priorities for the Commission. This is really looking at giving a more expansive interpretation of 612, which we thought, France is a principle that is difficult to apply. So I personally thought the Commission might, for now, shy away a bit going into that, but you see that they go into heads on. And you see that then also reflected in their DMA review report, in which they also seem to attribute to Article 612 a bigger scope than what we might initially have thought, actually mentioning things like, a value and, I don't know how concrete they were, but they do see it as a way of tackling more issues than narrowly tailored.
Mm-hmm.
I wanted to move our conversation a little bit to another topic, and then return back to your comfort zone. You all are top tier experts in law. You are competition lawyers. You communicate with your clients, but I wanted to remove you from this kind of capacity and uh, ask you as experts in DMA. The commission, the DMA team, has now generated and is in the process of continuously generating more and more unique expertise combined with quite generous discretion and competences to move priorities to other sectors, turn blind eye to some issues because they have scarce resources and because things are complicated and you cannot prioritize everything. They are engaged in continuous dialogue, multi-logue with different gatekeepers who are, as you, Stijn, mentioned, are also access seekers to some extent. Yes, so they act benevolently, not only in circumventing fashion. So it's a unique kind of ecosystem of regulatory knowledge is emerging. I imagine the same is applicable to CMA. What should be, how this knowledge, this new unique knowledge has to be applied for? What is the end goal? How should we read this fairness and contestability? Is it just serving the interests of most skillful, most loud, most eloquent business users, or these specific cases should be seen as a kind of as a jigsaw puzzle where we try to build something bigger? So should it be top down? Should we continue applying it in the kind of top down, so bottom up way, or we should somehow try to use DMA as an instrument for digital sovereignty or whatever the buzzwords on the political agenda is, and how much room for such flexibility is there, Amaryllis?
Go, it's giving me the hard questions first to answer. But yeah, I'll go. So I think there is different ways of looking at it. I think the most idealistic way of looking at it is really to see it as a way of, generally how you come to more stability and fairness, and for the commission to set the goals of how to best achieve that most effectively based on the resources they have, irrespective of necessarily who complains the most. I think the more I wouldn't go as far as calling it cynical, but maybe more realistic is that sometimes we see that priorities might, to some extent, be driven by, complaints by third parties, so that those cases might be picked up the quickest, and that then, the commission might go from there.
Great. Miranda?
I was going to say, I think there may also be a political element. So, to Stijn, your point earlier about in the context of content and data, that, we've seen some of these sort of cases that are a bit more creative are around, use of publisher information. I suspect that's not a great accident in the sense of, if you think about the bigger political picture about making sure that publishers, particularly European publishers, aren't effectively cut off from their ability to monetize, et cetera. There is a, I would say, small p political dimension there in the sense of preserving, the media, the press, information, ways of getting information to European citizens, the electorate, et cetera. So I think in some respects, there's probably a small p political angle to some of the choices that get made in terms of which cases to take in what order. And then the other point, I think, and you made this point, Amaryllis, at the top of the discussion, I think the commission does mean it when they say they actually much prefer to have a regulatory dialogue. And so the posture of individual gatekeepers in response to the commission, when the commission comes to them with, an objection or a complaint, would appear to be quite different. There is a significant range between the gatekeepers, even though there's only, whatever it is, 7 of them, as to how they respond and whether or not they entertain the idea of a dialogue that is intended to resolve a problem rather than perhaps a dialogue that may just be intended to buy time or something else. There's a huge range across not a very large number of companies. And I think that also has an impact, because my experience and what I can see is that, they may expect that if they go to company A, they might be able to get something resolved relatively quickly in 3 or 4 months, whereas, company B may not be prepared to entertain the discussion. And therefore, the commission, to some extent, at least very early on, was thinking, all right, if I need to get 10 things dealt with and 4 of them are going to be relatively straightforward and the others are not, then you could see the case teams are essentially looking for, I wouldn't say easy wins, but we're looking to make progress quickly on certain points, to the point about trying to open up ecosystems, trying to enable, changes of defaults, trying to enable interoperability, enable access, those sorts of things. In the early days, there did appear to be an element of, if we can get something resolved quickly, we'll do it fast. And then we'll come back to the more difficult ones.
Thank you very much, Stijn.
Yeah, I think I don't think you can expect a regulation like this to just magically change markets where companies have invested billions of euros into, building their technology and getting to the place where they are now, right? I mean, you don't just change that overnight by adopting a regulation. So the idea that we can somehow say, well, the DMA was or was not effective just because a company is still a gatekeeper 5 years later, I think is entirely wrong. And I think the fundamental changes in these markets are going to come from things that are not regulatory by nature, right? I mean, something like AI could potentially change the long-standing dominant position of Google in search, or maybe that does not happen. But what the DMA can do there, I think, is ensure at least that a company like Google in that particular context can't put its thumb on the scale to give itself an advantage that others don't have. And competition law can do that up to a point, but a competition case is limited to its own facts. We have the shopping case, of course, but that doesn't mean that every other form of self-preferencing is automatically also an abuse. Whereas if you have a rule that says, as a gatekeeper, you can't self-preference, that is a clear rule at the end of the day, no matter how complex you want to make the enforcement of that rule. And so I think that's really the role the DMA can play over the next few years in ensuring that new technologies have a fair chance of disrupting the dominance that exists in some of these markets. And that dominance, I think, is undeniable. But it's not necessarily there forever. And with something like the DMA, its demise could be sped up, I suppose. So that is perhaps what we can hope for more from a societal point of view. Now, should it play a role in things like sovereignty and all of that? I think there maybe, we should remain a bit humble as competition lawyers. And I mean, I don't think there are DMA lawyers yet, but that specialism is developing perhaps. But ultimately, I think that's more the area for politicians, where real investment is ultimately the answer, not only trying to regulate, and especially not through the DMA, because that's not a regulation that was written to promote European tech or something. I mean, that's just not why the DMA is there. So I don't think we should look at it for that purpose.
Okay, great. Let us now move back to the DMA, the legal side. I wanted again, as an observer, you are participants. So I wanted to ask you, when the proposal was tabled, the draft was proposal was drafted, how busy your time kind of started being, so you've been dealing mainly with ex post cases, good old, not very predictable, but at least you see there kind of you can do time management. Now with the DMA pouring on your shoulders so many different things, is it a different kind of universe? How what do gatekeepers and business users think about this? Is it kind of a very heavy regulatory burden and slash regulatory opportunity for others, or it is kind of they know their algorithm of defense or offense, and things are predictable and pretty much stable in your kind of daily legal juristic routine? Amaryllis, traditionally, you
I
open the
guess
floor.
sure. So I think it depends indeed which point in time you're looking at, because of course in the beginning it was the biggest lift for all the gatekeepers. You know, I alluded to it already in the beginning that all the gatekeepers needed to figure out exactly even what the DMA was, what it meant for their business models. A huge lift has been done by all the gatekeepers, putting in the engineering time, the lawyers' time to get to, you know, their initial compliance solution. So I think that was the most intense period for all the gatekeepers and for those helping the gatekeepers get to that position. You know, following that initial lift, I think there is definitely a different way of working than under traditional antitrust. Because there, you know, something kind of pops up at the commission, they open an investigation, and then, okay, then from then on you have RFIs, you're involved in this process, right? But actually under the DMA, you don't only have these specific events like an investigation, specification proceedings, which of course make it super intense at that period in time, both for the gatekeepers and for the external advisors. But you also have this regulatory dialogue that is constantly ongoing. And there's a lot of, even before reaching kind of that surface level, a lot of advisory work also going on to make sure that any kind of new business models or new products, that they are launched in a DMA compliant way. So you constantly need to counsel the client on these types of questions. And then there might be points that you proactively raise to the commission to see if your compliance solution aligns with what the commission had in mind, or ongoing points where there might still be questions to hash out with the commission that you constantly have these regulatory dialogues with. So I would say, you know, to some extent it is similar to traditional antitrust when there is a big investigation. On the other hand, it's also very different and reaches more into the traditional regulatory territory of having this constant dialogue with so to say, the regulator.
Thank you, Miranda.
Yeah, I mean, certainly what we're seeing, and we're compliance counsel to one of the gatekeepers, we, you know, it's a mix of, as you say, product counseling before products are launched, but then, you know, inevitably things go wrong, right? Tech breaks. And so there's a bug, or, you know, an update goes wrong, or something or other happens. And then there's a cycle of, you know, trying to understand what happened, why did it happen, is it a breach, etc. Because I think the thing to remember is, because the obligation here is on the gatekeepers, not just to once a year put out a compliance report that says we're compliant, but on an ongoing basis to maintain a sort of an internal function. They're explicitly required to maintain an internal function, to monitor and to make sure that they're compliant, and to put systems in place and all the rest of it. So it's actually a fairly significant obligation on the gatekeepers to take steps to ensure they are compliant. And so there is a, you know, they're required to have compliance functions, they're required to have a management body. There's all sorts of things in there on the, if you like, the monitoring and maintenance side that has required, as Amaryllis said, the early days, there was a lot of scaling up to get compliant, but there is now also, and increasingly automated, but still significant testing and other programs that go on for gatekeepers to ensure they stay compliant. So there's kind of an awful lot going on. You know, it may be a little bit like the proverbial swan, right? The gatekeepers sliding by looking all very serene, but there's an awful lot of activity going on under the water, right? And that often doesn't make its way into the public domain because they're desperately trying to make sure they don't end up on the receiving end of a non-compliance investigation.
Thank you, Stijn.
Yeah, and I mean, we as a firm don't act for any of the gatekeepers, so we're more on the other side of the debate when it comes to the DMA. And there, I think there's a bit of a split between those clients who were already invested in all of these issues, even before the DMA came into force. I think they are really waiting to see how things play out. They're not sort of looking for other ways to force the issues. I think they are perhaps a little disappointed in the lack of involvement in the proceedings. I think, as Miranda and Amaryllis have said, this is really more regulatory dialogue with the regulated company rather than some sort of broader ongoing consultative process. And that's probably also because at some point you just need to really get down to the detail of the issues. There is, of course, involvement for third-party stakeholders, don't get me wrong, but I think there was perhaps an expectation for there to be more of that. So that's the first group. And then there's the group of clients who have new issues where I think the DMA is really just one of a number of tools that can be used to resolve their issues. And a big factor there is, whether or not the Commission is looking to open new matters, is looking to have meetings with these stakeholders at an early stage. And if not, then of course you have to look to other approaches. So national competition agencies, if there is an Article 102 angle, or indeed the national courts, which is something that will grow more and more, I think, as the years progress.
Thank you very much. We only have a little time left, so I propose to reflect upon the private proceedings in the EU member states and in the UK. It's a too generic question. There's so many different sub questions. But if you can pick either your motto or some key message, or maybe a specific issue which you wanted to articulate and problematize, you are very welcome to do so, Amaryllis.
Yeah, maybe just on the point that Miranda made previously, right? That ultimately the whole DMA enforcement might become very fragmented. We've already seen those national proceedings starting in the DMA review report. They said there were about 10, maybe there's even more. And in each of these proceedings, specific topics of the DMA will be discussed and, might end up in Luxembourg as well, which means that ultimately, even though it's a commission who is the enforcer, it might lead to a more fragmented landscape, and which is obviously quite difficult ultimately for the gatekeepers to navigate. Put on top of that some national authorities, because they can't enforce something under the DMA, they might start already have national proceedings on more or less similar issues. I think it's just, challenging for the gatekeeper, who ultimately needs to have a compliance solution that works across the boards to take account of all these different stakeholders and procedures that are moving.
Thank you, Miranda.
Yeah, I mean, in that sort of vein, we're increasingly talking with, companies who are gatekeepers or VLOPs or VLUs and otherwise regulated, including subject to more symmetric regulation, so regulation that applies to everybody, like the Data Act and the AI Act, right, where there isn't that sort of selective nature of who is actually subject to obligations. The more conversations we have, the more we come away with clients agreeing that actually they need to be looking horizontally at these issues. You can no longer, unfortunately, go back 5-6 years and people could have their GDPR team, they could have their competition team, then they might have added a DMA team and then maybe a DSA team. But if you look at it at the moment, there's going to be so many silos out there with more to come, and all these other instruments like the the Meta judgment the other week, right, where there's a revision coming up to that kind of set of rules potentially, or else it maybe it's the AVMS directive that will be modified. So the more kind of the tentacles are spreading in the sense of different instruments that potentially apply to the activities of the gatekeepers. And so they increasingly need this sort of horizontal view. It's extraordinarily difficult for them to operate in a very siloed environment. And my discussions with the gatekeepers about these issues is it's requiring quite a significant, not just mental shift, but also internal structural shift, because you have all these subject matter experts on particular areas, and then somehow you need a way of joining the dots across the top. And we're having more and more discussions along those lines, because you need to think about the implications under different instruments of potential solutions, potential mitigations, to avoid that you don't end up with that something coming back to bite you situation, because you are solving for one problem without thinking about the other. And I think that complexity is, if anything, going to get worse. If the Digital Fairness Act and everything else happens, it will get more and more complex for these companies.
Can you just very quickly, Miranda, clarify? Because colloquially we think, okay, Meta case, partial annulment of the decision of designation decision, which the Commission has designated anyway, the core platform service. What is the legal
different Meta case? Okay. I'm talking about the AgCom case under the DSM directive. So that's the one where the court said that the Italians were entitled to require publishers to be compensated, right? So that's a different one from. So I should have been clearer. Sorry. I mean the Meta case on read the designations is interesting and useful, I guess, in the sense of it's confirmed a few things, like no, it isn't double counting to count users of a messenger service alongside users of a well, in that case it was Facebook, of a social media service. So that was useful in some respects. But this other DSM one, this one I was thinking of, where they essentially, the Italians have gone further than European law and effectively said, no, you need to compensate the publishers. And that was challenged. Coming back to the discussion we're having a little while ago about content and its increasing importance in something like the AI context, this interaction, whether it's the DSM directive, whether it's audiovisual, so AVSM directive, those things, and copyright, of course, are going to increasingly pull in alongside competition law, DMA, potentially DSA, depending on what you're doing with the content. So there's a increasingly complex picture of the things you need to comply with when your pro-old product developers and the engineers are out there trying to create something that they need to make sure they don't, trip over and need to be aware of early enough in the design process.
Thank you very much, Stijn.
Yeah, and on the complainant side, I think just like going to the Commission is not a magic bullet, the same applies to going to a national court, right? So I think with the DMA where it's currently at, and this may well change in the future, but it still makes a lot of sense for anyone who has an issue that is covered by the DMA to first find out whether the Commission would be interested in investigating it. And if not, to also really establish why that is the case, because that can both be the answer before a national court or a big risk for a claimant. Because, if there are issues with the claimant's case, then those are going to be flushed out before the national court. And, in most, perhaps not most, but I think at least in the main jurisdictions in the EU 27, you will find very competent and professional courts who will not just sort of grant an application for an interim injunction just because the DMA is there. I mean, they will want to engage with the complexity. They will want to engage with the European Commission, for which there is, of course, scope under the DMA, and they will put questions to the Court of Justice if they have to. So I think that is partly an answer to the risk of fragmentation, but I can certainly also see why my colleagues, on the other side of this debate do raise that risk, because it does, of course, exist when national courts start to weigh in on issues alongside the Commission. I think ultimately those issues are going to be resolved by the Court of Justice, but you could have periods within which you do have conflicting views, and we have seen that also with antitrust issues. So I don't think the DMA is immune from that.
In the last round, I propose, first of all, I invite you to reflect upon things which are relevant and yet you didn't have a chance to talk to mention. A. B. Miranda mentioned complexity and that it's only escalating with other mature strands or areas of law becoming more and more relevant for the DMA compliance mind and competition mind. So things are not only interdependent kind of hypothetically, but in your real legal routine. So I wanted to ask your maybe life hack. How do you just delegate? But even if you delegate, but you have excellent teams in your law firms. Yet you have to be updated, and it's not only kind of some briefed by junior colleagues. You have to deal with things which are getting more and more kind of really cacophonic, and yet you have to bring order, coherence, elegance of your argument, etc., etc., in communication with your clients, with regulators, etc. That's the second dimension. Amaryllis, you are always the first, and the last one. You keep recruiting because you're getting busier. So recommendation for those who are just about to finish their university law degree and who are really keen to work in this area of law. Which features do you search today which are not self-evident for traditional legal education? Or maybe you are still relying on good old qualities which are known but yet difficult to achieve. Amaryllis, please.
So where to begin first? Maybe just on navigating this complex field, I just want to confirm indeed what Miranda said, and not just that there is a lot of different instruments out there at the same time, and within the gatekeepers, they need to be on top of each of these to make sure that one solution doesn't go against another one. But actually, what also happens is that one regulation might not be, fully compatible with something in another regulation, or, the DSA team pushing for one thing and then the DMA team pushing against that. So you need to be very aware of those different obligations, pressures, and also conversations that the company has with different strands of the Commission. So I think for all of that, it's, as you say, super important that you're not closed off and say like, okay, what I do is DMA. No, you also need to be aware of, we talked about all these antitrust proceedings that have an impact on it. You have to have at least a view on the other regulations like copyright, DSA, Data Act, Cyber Resilience Act, AI Act, not necessarily be like the expert yourself, but at least be able to spot the issues and pull in other colleagues that are the experts in these fields to then provide a cohesive, holistic advice to the clients, because they don't think of it as, specific buckets. As Miranda said, they think of it as, holistic teams and solutions that need to be built, because a solution is worth nothing if it doesn't work under all the regulations that they're subject to. So I think the main trait that we would look at for people who are interested in joining this field is have this curiosity to really dig into, maybe one or two fields particularly, but then really keeping an open mind and this, just willingness to learn and always keep an eye open on what is going, so that you can provide this more holistic, and advice to the clients.
Thank you very much, Miranda.
Yeah, I think picking up that last point first, the characteristics, the just expect that you're going to be continually learning, right? All of us are. We are constantly keeping on top of not just the new bit of law, but the new judgment, the new sort of technical issues. So, for example, AI has upended the stack we've all been dealing with for the last 20 or so years, with, you know, operating systems up through browsers, you know, then with the apps being added alongside that. Those structures, in terms of where are the potential bottlenecks, where are the potential choke points, are being shifted completely by AI. And so you need to be able to make the mental adjustment to how the law applies to the different structure of these sectors. That also means you have to understand technically how they work. Now, I am far from being an engineer, but I would say anyone who wants to do these things, you do need to also be technically curious enough to understand how it works, so that you can actually figure out where the potential, you know, issues are, where are the access points, where are, you know, what's the concept that makes sense in this world if it's not interoperability. You know, those sorts of the ability to step back and just think about, yes, but in this context, how does that change my old mental model? We just have to do that. And so if you want to do this sort of this area, if you want to practice in the area, you want to do these sorts of cases, that's what you're signing up for, which is, I guess, why a lot of us really love it, because it's constantly changing, right? We're not doing what we were doing not just 3 years ago, but even 12 months ago. Things have shifted significantly. And so that would be kind of my suggestion to anyone who's thinking about the area. And I think it also comes back to the point I was making about complexity, et cetera. I mean, there absolutely are these cases where, you know, the obvious one is and I think the first one when this kind of became very concrete was the debate over the difference between consent requirements under Article 5.2 of the DMA and the GDPR requirements that was writ large in the Meta consent or pay situation, right? Now that has had a knock-on for everybody else as well, though, because now there is this broad question about, well, what is informed consent? We've got a sort of a coda, if you like, to that coming through with these the competition cases with against Google, whether or not the providers of the content, so publishers in one instance, YouTube uploaders in another instance, whether or not there was a viable opportunity to not opt in, i.e., you could actually choose whether or not you were going to consent. So those consent issues where, you know, we have a model under GDPR. Everybody thought they understood what it meant. EDPB is currently working on some new guidance because the omnibus attempt to modify the pseudonymization rules failed. So now the EDPB is looking at that in that context. For the rest of us who aren't pure GDPR lawyers, that has a knock-on back into all of the other laws that apply the same definitions. And you know, the DMA does it by reference. It literally incorporates by reference the GDPR definitions. So we need to stay on top of all of these other things that, you know, I need to keep half an eye on what the EDPB is doing, because it has a significant knock-on effect for the consents that are being obtained under DMA, DSA across the board by the regulated VLOPs, VLUs, gatekeepers. And so that joined-uppedness is something that I would say is relatively new. We've had to do it in the past when we were looking at regulation and competition law, but not at this level of complexity in terms of the overlaps, potential inconsistencies, even if they're not inconsistent, just reconciling how they apply. It's a different level than I think we've seen in the past.
Everything that Miranda and Amaryllis said, I agree with. Yeah, I think, you know, you just have to remain curious and, you know, continue to read, pick up on developments, you know, work in a partnership and in a team where you highlight these things to each other. You learn from your colleagues, and learn from your clients as well. You know, they might not be experts in your area of law, but they are experts on the technical side that Miranda mentioned, and on the, you know, specific commercial context within which they operate. And if you don't learn that side of the story, you're only really seeing a small percentage of the case that you're doing. And that also counts on the defense side. You know, you really miss potential defenses, I think, if you don't understand how the market works. That's certainly the case in competition cases. And, you know, advice to students or people just entering the job market now. Yeah, I think the reality is that, you know, jobs are probably going to change as a result of AI. You know, what I've been reading about that, which I think makes a lot of sense, is that developing a sort of ability for critical thinking is really, really important. And I think we also have to look at universities to play a role in that. You know, increasingly, I think the first draft of something is going to be an output of a machine rather than an output drafted, you know, by a junior lawyer. And that means that the role of the junior lawyer changes from drafting to more being able to really critically read those outputs, identify where it went wrong, where, you know, citations are not correct or incomplete, and learning to work with the technology in that way, which is going to be a big challenge, but also I think an opportunity because, you know, they are also going to be better able to work with those technologies than we ever were, having, you know, grown up with them. So there is, yeah, I think a changing landscape, and one that I think starters on the job market shouldn't sort of close their eyes to and think everything is just going to remain the same, because I don't think that's realistic. But yeah, develop critical thinking, and learn to trust your instincts when things are not quite right that you see on the page. Learn to raise those with your seniors within the firm at the right moment. That's all going to be essential, I think.
Amaryllis Müller, Miranda, Stijn Huijts, thank you very much for this excellent conference debrief, and we went beyond.
Thank you.